To introduce our guest for the call today, Professor Adam Mossoff. He's Professor of Law at George Mason University. He teaches and writes in the areas of property and intellectual property law and property theory, and has focused in particular on the intellectual history of patent law. He's published numerous articles on the subject, testified before Congress, and has been closely following the recent action on the so-called patent troll phenomenon and the efforts at the federal and state levels to address the issue. He has been in high demand for his analysis on this, given the two recent Supreme Court cases with significant implications on meritless patent litigation, as well as continuing high-profile legislative efforts. And so we very much appreciate Professor Mossoff taking the time to join us and to answer questions. I will turn it over now to Professor Mossoff to give about a 20-minute discussion of the issue, and then we will open the floor for questions.
Thank you, Alita, and I really want to thank the New Jersey Civil Justice Institute for scheduling this teleforum and for inviting me to speak to you today about some of the recent Supreme Court decisions that impact patent litigation and thus play a role in the current policy debates about patent litigation and whether the rules for how patent owners litigate their patents should be revised or not, either by ongoing action in the courts or in state legislatures or in the Congress. Now, for my remarks today, as Alita said, I will be speaking for about 20 minutes, and then we'll open it up for questions and answers. And in my introductory remarks, I'm just going to frame the broader issues about the patent policy debates today, then speak about two of the many cases that the Supreme Court has recently heard and handed down decisions on in the patent field. The cases are Octane Fitness and Highmark. They address the issue of the award of attorney's fees, and I'll talk a little bit about how these cases play into the patent policy debates about patent litigation. So let me start by just noting that we live in a world today with respect to patented innovation in which two very stark propositions stand in contrast to each other. The first is that we are currently experiencing some of the most explosive innovative growth in technology and other areas of patent innovation than we have ever experienced in history. In the areas in which there is very heavy patenting and there is extensive issuance of patents on new technology, particularly in the smartphone industry, we have some of the fastest technological growth that any industry that experiences patenting has ever experienced before, combined with never-before-seen drops in prices. So we have a combination of new technological innovation coming out at record pace, and we all know this from the experience of the fact that we all see a new smartphone being offered for sale, either from Apple or Samsung or HTC or Motorola or any of the other smartphone providers with all of these new features and capabilities, and that the prices are dropping on those phones. This is not just true for smartphones, it's also true for tablets, and it's true for computers generally. Computers today, desktops and laptops, in terms of the power and capabilities that they have, cost fractions, almost pennies of what those same capabilities in terms of storage, in terms of processing speed, and other capabilities would have cost you, not just 5 years ago, but if you're talking 10 or 20 or 30 years ago, you're talking orders of magnitude drops in prices compared to technological innovation. So that is on the one side, that we are, in effect, sometimes the way I put it is that we are using technology today that just 15 years ago was thought of as just science fiction. And you only saw it in science fiction, and now it is part of our everyday common lives. That's on the one hand. On the other hand, what we now hear today are extensive complaints about the patent system. One of the mantras that one often hears and sees stated again and again and again in newspapers and on the internet and in blogs is that the patent system is broken, that there is fundamental problems, systemic problems with the patent system. There are too many bad patents is the allegation. There's too much patent litigation is the allegation, and this is stymieing innovation. The argument is that, therefore, we need to revise the patent system again, we just had massive revisions of the patent system 3 years ago in the American Invents Act of 2011, and now the argument is we now need to revise the patent system again in order to address these fundamental problems in both patent quality and patent litigation. And these two propositions, as I said, stand in stark contrast to each other. The patent policy debates, which represent the second proposition that the patent system is broken, has really been driving much of the action that one has been seeing both in the courts and in Congress and in regulatory agencies. So there's actually wide-ranging efforts being undertaken in all branches of the federal government and even in the state governments to address the claim that the patent system is broken. So, for instance, the Federal Trade Commission is now investigating patent licensing practices and patent litigation practices and the sending of demand letters and considering taking action in those areas. The Federal Congress has recently been engaged in an extensive consideration of bills that would have made massive revisions to the patent system, touching on all aspects of patents, from licensing to litigation to obtaining them to further review of patents at the Patent Office. The Supreme Court has re-engaged with the patent system and with patent law to a degree not seen since the mid to late 19th century. I mean, that is the last time we saw the Supreme Court granting cert in so many cases as we see similar to today, and that's significant if only because in the late 19th century the Supreme Court did not have control over its own docket. So the Supreme Court had to hear all appeals that were filed with it at the time in the late 19th century. So of course they had to hand down decisions in many patent cases. Today they have a choice of which cases they hear or not. They grant certiorari on the cases that they do decide to hear, and so it's even more significant that they're choosing to hear so many patent cases. There was a significant number of cases just this past year addressing issues of the patentability of computer software, or what is technically referred to as computer-implemented inventions, the issues relating to the appropriate legal standards for how one drafts a patent application and describes the patent in the patent that ultimately issues. There was a case involving other cases involving patentability standards, as well as the two cases that we'll be talking about today. Although if anyone has any questions about the other cases, I'd be happy to address those. The cases that we're going to be speaking about today, though, because they relate to litigation and they relate directly to the role of patents in litigation, are the decisions that the Supreme Court handed down on April 29th of 2014, two companion cases, one known as Octane Fitness and the other Highmark. And the Supreme Court granted review in these cases to address the issue of what is the appropriate standard for the award of attorney's fees for inappropriate conduct in patent litigation. Now, the U.S. patent laws provide for the award of attorney's fees. In Section 285 of the Patent Act, the patent statutes state that attorney's fees may be awarded in, quote, exceptional cases, unquote. Now, the Federal Circuit, the Court of Appeals for the Federal Circuit, which has sole jurisdiction over patent appeals, has had historically construed exceptional cases in a very, very narrow manner. They made it very, very hard for district courts to award cases, and they reviewed those awards on what is known as a de novo standard of review, which means that they gave no deference to the district court's decision to award attorney's fees. And so they considered it all anew. And as a result of the very, very high bar that district courts had to meet, and the willingness of the Federal Circuit to basically effectively give someone who had been punished under Section 285 by being ordered to pay the other side's attorney's fees, the ability to appeal and get a second bite at the apple, for all intents and purposes, by getting to relitigate the entire issue again on appeal, there were very few cases in which attorney's fees had been awarded. And this was ultimately litigated, and the Supreme Court decided to grant cert on it, I believe, for two purposes. One had to do with the fact that the extent to which the Federal Circuit had construed Section 285 of the patent law was arguably not consistent with other construction, with similar statutory provisions, such as in the Copyright Act and in other areas of federal law involving the award of attorney's fees. And I believe the Supreme Court was interested in this issue because of the large public uproar about patent litigation today. As I mentioned at the opening of this teleforum, there's extensive complaints about patent litigation today. There are arguments that we are seeing a patent litigation explosion. That there are claims that there are special entities that are just litigating patents. Now, of course, there are bad actors in every legal system, but the argument today is that the bad actors define the entire patent system in its whole. These are arguments that are debatable, and we can talk about that perhaps in the question and answer period. But for purposes of just identifying why the Supreme Court was interested perhaps in granting cert in these cases, I'm raising them because I believe that they played an important role in the justices thinking about the need for review of the standards for awarding attorney's fees in patent litigation. So the two cases, the reason why they granted cert in two cases is because each of the cases stood for a slightly different proposition with respect to the award of attorney's fees in patent litigation. The Octane Fitness case addressed the substantive standards. So what would be the actual test substantively that the district courts would have to apply in deciding to award attorney's fees? And then the Highmark case addressed the standard of review. So if a district court decided to order one of the parties to pay the other party's attorney's fees because the other that party was deemed to have engaged in abusive litigation practices or brought a case that should not have been brought, then what would be the standard of review that the Court of Appeals to the Federal Circuit should employ in reviewing that decision on appeal? So with respect to the substantive standards in the Octane Fitness decision, the Supreme Court overruled the Federal Circuit's prior tests that they had announced for the appropriate award of attorney's fees under Section 285, and they did so on two grounds. They overruled both the substantive legal test and they overruled the amount of evidence that a party had to submit in order to prevail on their claim that attorney's fees should be awarded. So with respect to the substantive legal test, as I said, the Federal Circuit had created a test that was very, very hard to meet. It was essentially a two-factor test that required that there be first some, quote, material inappropriate conduct, unquote, and secondly, that the litigation had to have been brought both in, quote, subjective bad faith, unquote, and was, quote, objectively baseless, unquote. Now, the Supreme Court overruled this test and did so because it maintained that it was not consistent both with the meaning of exceptional case as this term has been construed by courts in other contexts, as well as its meaning in the original enactment of Section 285 in 1952. Here, the court relied upon some of the legislative history, and just for those who know about these disputes in the U.S. Supreme Court about the role of legislative history in construing statutes, these disputes continue in the patent context as well, and so the places in which Justice Sotomayor's opinion relied upon the legislative history for the 1950 Patent Act were cases in which Justice Scalia filed a concurrence in which he noted that he was not joining the opinion with respect to those aspects of the opinion where she relied upon legislative history. Otherwise, the decision was unanimous, both Octane Fitness and Highmark. So what the court ultimately held was that the way in which to construe exceptional case was by the classic kind of traditional discretionary authority of courts to manage their own dockets and to punish bad behavior in litigation, and thereby they should make the decision on the basis of a, quote, totality of the circumstances, unquote, test, essentially assess the whole totality of the circumstances, kind of a case-specific, holistic, equitable analysis that really is in accord with the long-standing authority in all Article III courts as well as in state courts to manage their own dockets and to punish bad behavior by litigants. They also lowered the standard, the evidentiary standard, to prove bad behavior. So previously, the Federal Circuit had held that that a district court could only award attorney's fees if it had been proven by clear and convincing evidence, which is the highest evidentiary standard that one has in civil litigation. It's the equivalent in civil litigation of beyond a reasonable doubt in the criminal law. It really is a very, very high hurdle to meet, and the Supreme Court lowered the evidentiary standard to a preponderance of the evidence standard, which means simply that one has to prove by 51% or more of the evidence has to weigh in favor of the argument. So as you see in Octane Fitness, the Supreme Court substantially lowered both the substantive legal test as well as the evidentiary requirements to meet that legal test for a district court in exercising its discretionary authority to award attorneys' fees and punish bad litigants that have appeared in their court. In the companion case, the Highmark decision, the Supreme Court reviewed the Federal Circuit's standard of review. Traditionally, as I said, the Federal Circuit had deployed a de novo standard, and again, the Supreme Court noted that this was contrary to long-standing court practices with respect to the award of attorney's fees. Since these are inherently fact-based, equitable decisions that rest in the discretionary authority of a trial court judge who is able to witness firsthand the behavior of the litigants through their motion practice and other activities in the court, which is something that the appeals court doesn't have access to because they're simply looking at the black and white printing of the written trial record. They changed the standard review from de novo to abuse of discretion, which is very significant because that means that a trial court, in deciding to award attorney's fees, that decision will likely be upheld on appeal because it's very, very hard to reverse a trial court's decision under the abuse of discretion standard. That is the most protective standard for a lower court's decision in terms of standards of review. So what you have, therefore, in the Octane Fitness and Highmark decisions is a very significant, effective 1-2 punch with respect to the ability of courts to manage their dockets and to punish bad behavior by litigants who are going to the court system and are bringing cases that they shouldn't be bringing or are engaging in bad behavior in cases that could have potentially been appropriate even if they were brought by good actors. So, and the sense was that this was necessary and important because that there were actually some bad actors in the patent system. There was some concern when the decisions first came down that but the standard is still exceptional case, and so it'll still be difficult for trial courts to exercise their authority under Section 285 of the Patent Act. But this is actually proven not to be the case. There have already been now several cases where trial courts have awarded attorneys' fees in the approximately month and a half or 2.5 months since the decisions in Octane Fitness and Highmark were handed down. That is, in terms of rates of awards of attorney's fees, a very, very high rate relative to what was occurring under the previous tests that had been announced by the Federal Circuit, in where you only had several awards of attorney's fees over the span of many years. And those awards have been upheld on appeal, given the de novo standard of review. So what you have here is, I believe, a very, very, very important change to patent litigation. And significantly, it's a change that should have occurred. Because if we are talking today in the patent policy debates that there is in fact problems in litigation, and those problems arise from bad behavior by litigants in litigation, then historically and under our separation of powers, it has been the domain of the courts to address those behaviors. And this is in fact why courts have historically had the authority to award attorney's fees and costs, going back hundreds of years, and it's been codified both in the civil rules of civil procedure, for instance, Rule 11 sanctions, as well as actually in the statutes themselves, in the copyright statutes, and the patent statutes, and in other statutory regimes, as well as in statutes enacted at the state level. And so this is important because it shows that the courts are being responsive to the actual existence of bad actors in their court systems, that the Supreme Court is responsive to this, and that they have actually changed the legitimate rules in a legitimate way for the courts to address those particular bad actors. But more importantly, it is a change that authorizes the courts to address the bad actors without harming the good actors. Because this is one of the real concerns that has been raised about the broader policy debates in which people are advocating for extensive revisions to the patent system through Congress or the regulatory agencies. In particular, the efforts in the U.S. Congress and in some of the efforts at the state level through legislative changes to patent litigation, such as the proposals to adopt mandatory fee shifting, raise serious concerns about over-inclusiveness and the fact that they would sweep within their prohibitive effects not just the bad actors but the good actors as well. So, thus, for instance, the bills that died in the Congress this past year that were being considered for enactment and got very close to being enacted into law, adopted a mandatory fee-shifting regime in patent law. So instead of following kind of the long-standing traditional role of fee-shifting that you have throughout the entire litigation system, it adopted for patent law a mandatory fee-shifting regime that applied to every patent case, to every patent owner who brought to court a claim that their property rights had been infringed and they were seeking remuneration for that infringement, or at least an injunction to help them therefore enter into a licensing deal in the free market. And so the rule under consideration by Congress was that there would be a mandatory fee-shifting regime in which which then parties would have to affirmatively argue out of, as opposed to the other approach, which is that no fees should be awarded and costs should be paid if, in fact, someone had engaged in bad behavior and that you could affirmatively prove it. This flipped that and made it actually mandatory fee shifting, with having to provide affirmative evidence that you shouldn't have to award attorney's fees. Now, that was significant because, as I said, it swept into its effects good actors. And this is even more important because not all good patent owners are massively funded, heavily capitalized companies that have been in existence for decades and therefore can bear the risk of having potentially to pay millions of dollars in attorney's fees. In fact, the majority of innovation in our country comes not from large existing corporations that are established actors in the innovation industries, but instead comes from individuals and startups who are vying with these larger existing actors with disruptive technology and disruptive innovation to innovate, to recreate and restructure our lives, such as with smartphones and tablets and personalized medicine and viral drugs and other sorts of great sources of patent innovation that have revolutionized our lives. So individual inventors, small startups, universities, and other entities potentially faced extreme difficulties with enforcing their property rights against would-be infringers under the proposed legislative changes in Congress. And therefore, this is why the Supreme Court's decision to weigh in on this issue and to change the law in a way that is balanced and reflects both court's traditional authority to manage their own dockets, punish the bad actors, but not negatively impact the good actors, is a significant factor in the public debates about the patent system. And I believe that these cases and the follow-on district court decisions who are awarding attorneys fees, I believe, will play a significant role in the ongoing debates that we have about whether the patent system needs to be revised. So with that, I'd like to end my kind of opening remarks and now take questions from the audience. I hope that there are lots of questions and we'll have a good discussion.
I will start this off, and so my first question to Professor Mossoff is, I've been seeing a lot of stories in the press about the patent troll phenomenon, and a lot of times the patent troll is sort of a term that's just used without a lot of broader, without a lot of specific explanation of what that means. Is there a universal or settled definition of this term, what would you say about that?
Okay, thank you. It's interesting, Leah, that you asked that question. You probably noticed, as did the audience to this teleforum, that I did not use the term troll in my remarks, and that was very deliberate. And it's not because I don't recognize that there are bad actors in the patent system. There certainly are. There are, and these are the people who the trial courts are already awarding attorneys fees to the other side, again in litigation with, and who have already entered into some settlements with some state agencies and other government actors with respect to some deceptive and misleading demand letters that they've been sending out. But one of the problems in the patent policy debates today is that there is actually no settled definition to the term patent troll. The term has been around and has been used extensively for about 15 years or so, and it has morphed over those years. And for a long time, it was largely through the 90s and early aughts. It was the person who, it was the person who I was litigating against. It was effectively the only thing that seemed to be that people could agree what this term meant. And so, one sees the usage of this term with respect to, well, it's the people who assert bad patents, or it's the people who don't manufacture, or it's the people who just litigate, or it's the people who and the problem with these varying definitions is that they invariably include good patent owners, people we don't want to necessarily attack as patent trolls, but nonetheless have been attacked as patent trolls precisely because they meet the definition of what a patent troll is. As that person has been deploying it. So, for instance, the types of entities that have been accused of being patent trolls, universities have been accused of being patent trolls because they don't manufacture. They just license their technology, and they sue people who are infringing that patented technology that they licensed that was created by their professors. And when people say that's not true, universities haven't been accused of patent trolls. No, actually, University of Wisconsin, through its tech transfer office, it's known by the acronym WARF, has been identified as one of the top 10 patent trolls in some articles. Carnegie Mellon, which won a very large damages award in a patent case about a year ago, has been accused of being a patent troll. And so there actually are numerous instances in which universities, which create new innovation, and then because they're not manufacturers, their job is education and research and development, that they then license that technology in the marketplace to people who are manufacturers, they're accused of being patent trolls because you're not manufacturing. Other individuals and entities that have been accused of being patent trolls are companies that are typically whose primary business model is licensing, but nonetheless, what a lot of people don't realize is that they create their own innovative technology that they obtain patents on it. So, for instance, Intellectual Ventures, which is often identified as a patent troll. In fact, it's been identified as the number one patent troll in some news report articles. Actually employs hundreds of its own inventors to come up with inventions in these massive warehouses in its headquarters in Washington, which it obtains patents on and then licenses because it's not in the manufacturing business. In fact, Intellectual Ventures models itself after Thomas Edison, who himself created an invention laboratory at Menlo Park, and then licensed or sold his patents to other people to then manufacture, because he himself saw his specialization in invention, not in manufacturing. And in fact, when Thomas Edison later decided to engage in manufacturing, he failed horribly at it. He should have stayed with just invention and then licensing his inventions, because that's where his expertise was. Also, individual inventors have been accused of being patent trolls. In fact, the very first prominent usage of the phrase patent troll in the public policy debates was in the 1990s, when Research in Motion, before it changed its name to BlackBerry, the owner of BlackBerry, was sued by a company called NTP in the 1990s for infringing its valid patents on telecommunications technology. NTP was what we call a licensing company or non-practicing entity, although licensing is an act of practicing one's patent rights in the marketplace. And so a lot of people accused NTP of being a patent troll at that time. This is well recorded and established. What a lot of people didn't know is that NTP was actually a wholly owned company created by the inventor of the technology, because he had actually failed, unfortunately, at trying to manufacture and to sell his patent innovation in the 1980s. So he formed this company to license it to manufacturers. And there's many, many, many other examples. So what you see is that the one thing that people seem to talk about when they say there are patent trolls is that this is an entity or an individual who engages in licensing and not manufacturing. But there is no reason for us to privilege manufacturing over licensing. For the same reason we don't privilege, from a perspective of property law, someone who actually buys a parcel of land to live on it, as opposed to someone who buys a parcel of land to build an office building or to build an apartment building, who then rents out, in other words, licenses out their property rights to other people to use it. And in fact, licensing has been a fundamental component to what it has meant in the American patent system to protect property rights and innovation. It's been a key feature of the American patent system and its success in buttressing the innovation economy that has been the foundation of the United States since the 19th century. I mean, as I mentioned, Thomas Edison engaged in this activity, and other very famous, prominent American innovators did, such as Charles Goodyear, the inventor of rubber, Elias Howe, the inventor of the lock stitch, and many, many others.
That's really interesting. So it sounds like what you're saying is that effectively what this would do is sort of illegitimize the business model of a small-scale inventor monetizing their own inventions.
Yes, and not just. I think that's an interesting way to frame it, and I think that's exactly right. Is that at root, what the patent troll rhetoric leads people to do is to condemn the business model of licensing, and from the perspective of economics, that is a very strange thing to do, because because licensing is an embrace of the division of labor, of market specialization, which is the key, which is the foundation to a successful, flourishing free market and economic growth. I mean, this was Adam Smith's grand insight in The Wealth of Nations in 1776, that it's division of labor, which is what makes it possible for, in his example, was the market to make a pin that is so cheap. It's division of labor that makes it possible for us to buy such cheap computers and smartphones and other types of patented innovation. And therefore, I believe that we should be concerned about condemning the very business model that it's based upon. It would lead us, by the way, to condemn not just small inventors who engage in this practice, but large companies who also have business models of licensing, companies that have been around for a very, very long time, like IBM. IBM for a lot of people don't realize is IBM doesn't make products anymore in the fundamental sense. They don't make computers. They don't, like they used to. I used to have an IBM computer. You can't buy those anymore. I just dated myself, but that's okay. What they primarily do is license their innovation. And many companies who engage in manufacturing, like Apple and Microsoft, also have extensive licensing programs where they enter into efficiency-enhancing agreements with other market actors in order to make possible the more effective, efficient delivery of new patent innovation to the hands of consumers. Now, I also want to quickly just point out that I don't deny that there are some bad actors in the patent system. There are some people who, there are some fly-by-night operators and some others who, get their hands on a patent or two or a couple patents, and they just try to make a quick buck on this by engaging in some deceptive and misleading practices, either in their business communications or the legal communications with other entities, or they engage in bad patent litigation. But we need to be concerned and wary about whether we can effectively address those bad actors in the system, either through the courts or through very narrow targeted legislation, without harming the good actors, the IBMs of the world, the individual inventors, the universities of the world, in a way that actually undermines the very foundations of our innovation economy.
Okay, let me see if there's anyone in the queue now.
Hi, I'm calling in from Canada, and we historically have had fee shifting as an integral part of our civil litigation system. However, it's based on a legislatively mandated tiering scale based on the nature of litigation. I was wondering if you could provide some background on how the fee awards or shifting works in the patent case in the U.S., and whether you think that might be the next area of contention or legislative intervention.
So I can't speak to the tiering idea, but as I mentioned in my remarks, I mean, what we previously had with respect to fee shifting and the payment of attorney's costs was kind of a very high legal standard that made it very difficult to meet, as well as a very a de novo standard review where the Federal Circuit was willing to reverse trial courts on their award of attorney's fees. And so we didn't have very many attorney's fees in cases in which fees have been shifted had occurred. As I mentioned, it's starting to occur now, but unfortunately we don't have enough cases. I said that it's occurred already now in several cases. We really don't have enough yet to identify any significant patterns, or to identify yet what are the actual factors that would seem to be playing a significant role in trial courts' decisions to award attorney's fees or not. I think that what we're going to see is probably within the next 5, 6, 7 months, there will be many more cases where trial courts will have either awarded attorney's fees or will have denied the request for award of attorney's fees, and you'll start to see crystallize through the court decisions various factors that I think that the courts would be identifying as significant factors in the award of their of attorney's fees or the denial of those attorney's fees. But it's too hard at this point in time to say that what those factors are. So I'm sorry. It's just we're in a period of kind of doctrinal upheaval at the moment, and so the old law is out, and what will happen under the new law has yet to remain to be seen. With that said, what you might see is some trial courts saying, well, this is a licensing entity, it doesn't manufacture, and that's going to be a significant decision that we're going to focus on. I don't think that that's going to be a factor that will probably survive as a factor if it does arise in the decision making of trial courts. It was argued under in the debates over remedies and the award of injunctions that followed from the Supreme Court's decision in Merck Exchange v. eBay. Where the Supreme Court handed down a 4-factor test. The fourth factor is public interest weighs against this, and it was argued at the time by many people that, well, it's against the public interest to have patent licensing, and that proposition has been rejected by both trial courts as well as the Federal Circuit. What the courts do seem to focus on and this is the appropriate metric or focal point that they should be looking at, is behavior. What is the person or entity or attorneys doing? Are they, filing needless motions? Is there evidence that they actually had that indicated the patent was perhaps invalid? Was there did they have was there some indication or evidence that they knew that the party was not actually infringing the patent, and other sorts of things of that sort that will probably play a significant role in the decision as to whether to award attorney's fees.
Okay.
Hi, Adam. This is Emily from New Jersey Civil Justice Institute, and I have a couple of questions for you. First is, if you were a small business lawyer practicing, and you had a client come to you that had gotten a letter claiming that they were violating patents, and it seems kind of fishy, are you going to tell them, let's take a gamble and take this to court? And what if they think they should just pay and settle?
Well, so it's hard. I don't want to provide legal advice. I can't provide any legal advice, especially over the phone or to people who aren't my clients. I don't have an attorney-client relationship with. But the reality is that there is a tremendous number of resources in today's incredibly networked and world for people to turn to if they receive a demand letter from an owner of a patent. And they should take advantage of those resources. They should research the entity that, they should go online and research the entity that is that has sent them the demand letter. Some of the bad actors have never filed a single patent infringement lawsuit ever. And this is one of the arguments that these entities are engaging in effectively a type of shakedown, because they don't intend to go to litigation. They don't intend to file a patent case. They're just trying to scare people. Also, there are various resources, and in fact there are pro bono services being provided by some law school clinics through partnerships between various trade groups, trade associations, and law schools for provision of legal services for people who receive, particularly small businesses and individual owners of businesses who receive demand letters from patent owners. So I would highly recommend researching those clinics and contacting them to see if they would be willing to provide or could provide some free legal service or advice. The Electronic Frontier Foundation also has some websites that it has created, and it has actually brought some challenges at the Patent Office through the various administrative procedures that were created in the American Invents Act to address patent quality. They've actually brought some challenges at the Patent Office to address the entities who are deploying patents that are alleged to be of low quality or shouldn't have been issued at all. So people talk about the fact that, the Internet and technology has made it possible for fly-by-night operators to engage in a type of extortion through the legal system by sending demand letters that are misleading or deceptive. My response is that people can use those same resources, the same technology, the same availability of information on the Internet to find out what is the appropriate response that they should engage in given their circumstances and the nature of the entity in the letter that they have received.
Thank you. And then the second question I have is, what's going to happen in states like Vermont that have passed a state-level law about this issue?
Well, there's actually been, there's been a tremendous amount of activity at the state level at this moment with respect to, not with respect to patent litigation as such, because patent litigation occurs in federal courts, not state courts, because it's federal law, but with respect to the sending of demand letters. For those of you who don't know what demand letters are, that's the letter that is sent by a patent owner to someone that they think is infringing, that they discovered may be infringing their product, saying, I believe you're infringing my product, we need to talk, because because I think you're infringing my patent, so we need to talk about whether you need to pay me a royalty or not. And if you are infringing, you need to stop because you need to pay me a royalty. And demand letters have long been an important function of the patent system and of patent litigation, because it's the way in which patent owners put other people on notice that you actually are potentially infringing my patent, and we need to have a conversation about that. And so there are many companies, in fact, for instance, a representative from Qualcomm testified at Congress this past May before the House Energy and Commerce Committee, where I testified as well, about how they see demand letters as a positive first step to entering into licensing negotiations. And in fact, many market actors in the innovation industries begin licensing negotiations after the receipt of a demand letter. And so that they're very much a process of licensing of patent innovation. Of course, just like in all areas of the law, in contracts and commercial law and regulatory law, any good actual legal mechanism can also be exploited and strategically abused by bad actors. And so you have some people who have engaged in deceptive and misleading tactics with respect to the sending of demand letters. And so while Congress has been considering what to do, states have enacted various laws. Vermont and North Carolina and Virginia and other states have enacted laws with respect to this. And now Congress has now considering, as I said, at the House Energy and Commerce Committee, they just voted on the markup of a bill specifically targeted at the practice of sending deceptive and misleading demand letters. This is probably an area which is exactly where you could have actually a good revision to the patent system, because it's not, first of all, wide-ranging and expansive, changing everything for all patent owners. It actually is a very narrow, targeted issue. It gets at a very specific practice. And moreover, it gets at a practice that you may possibly have to have legislation on, because it addresses the sending of demand letters, particularly by some bad actors who never bring any cases to court, and therefore they don't subject themselves to the potentiality of being told that they have to pay the other side's attorney's fees because they're simply sending the deceptive or misleading demand letter without any intention of filing a lawsuit. So in these cases, it's good to prohibit this. It's arguable that that state laws prohibiting deceptive and misleading statements by businesses and other actors in the innovation economy already apply to these practices, but to the extent that you don't have the application of existing laws to these entities, or there's some question about what should be the legal standards that apply to them, then this is actually an area where there's some good legislation could be passed to emphasize that this type of behavior is prohibited and should not be engaged in. Unfortunately, some state laws go too far, and they commit the same mistake that the broader proposals to revise the patent system commit by sweeping within their prohibitive effects good practices and good entities who would then face the threat of someone who actually is infringing, strategically using the law against the good owner of the patent who's trying to stop the infringement or is trying to enter into a licensing agreement. So this is particularly the case in some states which have criminalized under their state antitrust or their state competition laws, the sending of deceptive demand letters. That creates a tremendous ability for someone who receives a legitimate demand letter to say, well, who wants to infringe, to say, well, I'm going to impose all these costs upon you by appealing to the Attorney General to actually bring a criminal action against you. Moreover, some of the legislation actually requires, for instance, that the demand letter reflect a, quote, reasonable amount, unquote, that is requested as a license fee. Well, what counts as a reasonable license fee is very much an issue that is debated among parties in patent litigation and even in licensing negotiations to this day. And so it's, every person who receives a demand letter or is in licensing negotiations, and the reason why negotiations take months is because very oftentimes there's open dispute between the parties, at least initially, as to, well, what counts as a reasonable amount that should be paid as a royalty for the use of the property. And so we have to be very careful and ensure that if, to the extent to the laws that are being enacted by the states, and some of those laws are, I worry, are too broad, but so this is why I think the federal legislation is actually pretty good, because it's fairly narrow, gets at the actual bad behavior as opposed to encompassing other issues that then end up including the good actors who are actually using demand letters in the way that demand letters have always been used in the innovation industries as a mechanism to start licensing negotiations.
Hi, I just want to follow up my original question. I think I might not have been clear. I was asking about quantum of the fee award and not so much the process in determining whether or not it will be awarded. And again, by analogy, again, here in Canada, there's a structured system. So while your actual legal costs incurred could be millions of dollars, your actual fee award could be hundreds of thousands or even tens, depending on the nature of the case. And I was wondering if, again, if there's any guidance or movement in that area, or if you expect to see that as these decisions become more common.
Oh, okay. So the award of attorney's fees can be and is a complex area, because very oftentimes it's part of the adversarial process where one party says, yes, we expended $10 million in attorney's fees, and the other side says, well, wait a minute, there's because you have $1 million in there for photocopying costs or something, and they say you filed 10 motions, and 10 motions couldn't have cost $1 million, and things of that sort. So there's always these types of debates about what is the scope and legitimacy of the award of attorney's fees. Under Section 285, it says actually that in exceptional cases, a reasonable attorney's fee shall be awarded, which means that it's within the discretion of the court to determine what actually should be the attorney's fees awarded, whether it's actually the amount spent, or whether it's the amount that the court determines should be spent or not. These are very complex issues, and you get varying court decisions with lots of different factors and things that they look at elsewhere. I don't know, and unfortunately I'm not an expert enough in attorney's fees jurisprudence broadly to say which factors would be really important or where they may be going in this regard with respect to patent litigation. So I'm sorry for that.
Okay. I just wanted to, Professor Mossoff, just wanted to follow up then myself on your comments on efforts to address the patent demand letter phenomenon. I wanted to just see if I'm clear. It sounded like what you were saying was that this would maybe be in part because of the familiarity with the courts in addressing these issues. This would still be an issue that is better addressed at the federal level.
Well, to the extent that sorry, let me start again. Yes, I believe it is probably best addressed at the federal level. As I said, this is why the current legislation that is being under consideration in the House has come up and is supported by numerous and wide-ranging stakeholders in the innovation industries. And the reason why it's probably best addressed at the federal level is for the same reason that we put patents and copyrights into the Constitution in the first place at the Constitutional Convention of 1787, and that one of the very first things that the very first Congress did in 1790 was enact patent law and its copyright laws. I mean, this is a Congress that spent months debating how they were going to refer to President Washington. Do they call him His Excellency? Do they call him President Washington? Do they call him Excellent President Washington? Do they call him Mr. President? And yet, while they were debating that, they immediately and very quickly voted on and enacted into law the patent laws and the copyright laws, because they recognized that patents and copyrights are property rights that are deployed on a national level. Innovative technology and creative works are sold in the marketplace in every state of the union. And so uniformity in those laws across the entire country is fundamentally important for the owners of that innovation, I'm talking solely about patents at this point, to be able to make the types of investments today, hundreds of millions of dollars, not just in coming up with the new innovative technology, which is, by the way, just as true in the high-tech field as it is in the biotech and pharmaceutical industry. A lot of people don't realize that that software is very expensive to create, because people think, oh, well, software is like an app on their phone, like Flappy Bird or Angry Birds or one of the other games we play, which is created in maybe a couple days or maybe a week or so. But what is referred to as enterprise software, so operating systems like Apple or Windows, and the massive programs that we actually use on our computers, like our email clients, our word processors, our browsers, actually consist of hundreds and hundreds of millions of lines of code and cost billions of dollars to develop, test, and actually then deploy in the marketplace. And so there's massive research and development, not just in the creation of the new innovation, but also then in the follow-on commercial deployment of that innovation. So what a lot of people don't realize, too, is that the significance of licensing is not just that people can engage in specialization, but that commercialization, the act of taking a product from the lab and converting it into something that is actually sold in the marketplace, can take years, because it takes that much time to set up the supply chains, to create the agreements with the manufacturers, to create the retail distribution mechanisms and things of that sort. For instance, it was years between the invention of the iPhone actually in Apple's labs to when they very first started selling it in 2007 to consumers. And so that is exactly what our patent system as a national property rights system is intended to ensure, to protect, and to support, is the effective, efficient deployment of new innovation throughout the entire country. And so, unfortunately, when you have varying state laws with varying differences in standards of what counts as, for instance, a deceptive demand letter, and variances in penalties, whether criminal or civil or both, this creates severe problems for the very people who are investing in the millions of dollars to create that innovative technology, because now they face the potentiality of, well, I could potentially be thrown in jail in North Carolina, or I could potentially be held accountable to millions of dollars in fines in another state, or not, or in one state requires this, but another state requires that. So in a sense, this is, I think, why legislation at the federal level is probably best. It effectively meets the needs, the core needs of our innovation economy to flourish and to continue to bring us the incredible new products and services that we have. And this is why that the bill under consideration in the House of Representatives right now actually has a preemption clause in it, and I think that preemption clause is actually quite good for the very reasons that I just discussed.
Great. And then my last question relating to that is, pending federal action, are there any legal tools that exist right now to address the problem?
Oh, yeah. So I've touched on several of them throughout the course of this call. Of course, the obvious one is for the bad actors who actually are bringing lawsuits inappropriately in court. We now have the tools that have existed, and they've now been freed up to use them more effectively of the award of attorneys' fees and costs to the other side, who has suffered the pain and anguish of having to litigate when they should not have been able to do so. And there's, as I said, there's evidence that the courts are now deploying this tool in exactly the way that it was intended to be deployed, along with kind of what is the inherent authority of Article III courts to use this tool in the award of attorneys' fees. There's also, as I said, as I mentioned, there are existing laws prohibiting fraud and other types of deceptive practices by commercial entities in the marketplace, and these laws would apply to the sending of deceptive and misleading demand letters just as much as to any other deceptive or misleading act that is engaged in by a person in our society who ends up imposing or harming another person as a result of that deception. There's also, very importantly, and I just made a brief reference to this earlier in the call, the numerous programs that now exist at the Patent Office to review patents that have been issued. These programs were massively expanded in the American Invents Act of 2011 for the purposes of addressing what was alleged at that time and continues to be alleged to be a patent quality problem. And in fact, these programs are being used and called upon to a far greater extent than people ever imagined. There's been thousands of review applications that have been filed. They thought initially that people would just slowly start to use these things, and the Patent Office is actually having to hire tens and hundreds more administrative judges to hear and to sit over these review programs because they're being taken advantage of so much more than what people realized. And because underlying some of the complaints about patent licensing entities, or at least the bad actors, again, is that they have bad quality patents. And thus, for instance, I just mentioned the Electronic Frontier Foundation to much publicize the fact that they have actually filed for a review of some of the bad patents that have been deployed by the bad actors in our system today. Those are just a few of the opportunities and tools that courts and the agencies like the Patent Office, who have expertise in the patent system, have at their hands to use to address bad actors. And in fact, former director of the Patent Office, David Capos, actually said, we should actually be careful about adopting more revisions to the patent system, because we should wait and see how the revisions that we adopted in the American Vents Act, and now I believe the revisions to the patent system, to the litigation practices that we've seen from the Supreme Court, are being deployed and are being used before we start making further revisions and creating more uncertainties for the innovators who are using the patent system to both create and put into our hands new technology.
So I think with that, we will thank Professor Mossoff very much for his time and a very interesting discussion.
All right. Well, thank you very much. This was great. There were great questions, and I really appreciated the opportunity to talk about this important issue.